Hello and welcome back to my channel. Today we will discuss the hijab law in Karnataka, the background behind it, and what is the issue. In December last year, Udupi's Kundapur PU College issued a circular banning students from wearing hijabs in classrooms, claiming it was to ensure uniformity in classrooms. This decision led to uproar, with some students not being allowed to enter classrooms by college staff and fellow students. Similarly, students were stopped from attending colleges for wearing headscarves instead of full-length hijabs. This matter escalated further. Students from the other community started wearing saffron scarves to college in protest against the hijab-wearing Muslim students. After a violent clash between police and students in Bengaluru, the state government issued an order imposing a ban on the wearing of clothes that tend to disturb equality, integrity, and public order, and imposed Section 144 in select districts. Now, what was the government order? On February 5, the Karnataka government passed an order exercising its powers under Section 133, Clause 2 of the Karnataka Education Act 1983, which grants the state to issue directives for government educational institutions to follow. In 2013, under this provision, the state had issued a directive making uniforms compulsory for education institutions. Referring to the 2013 directive, the latest directive specifies that a headscarf is not part of the uniform. It states that wearing a headscarf is not an essential religious practice for Muslims that can be protected under the Constitution. The order takes refuge in 3 cases decided by different high courts to hold that banning the headscarf is not violative of fundamental rights, particularly freedom of religion. The students went to High Court and the Karnataka High Court passed an interim order in which it restrained all the students, regardless of the religion or faith, from wearing saffron shawls, bhagwa, scarves, hijabs, religious flags or like within the classroom. And it clarified that the order is only applicable to those institutions which have prescribed a uniform dress code. Now the issue comes to the point where the order has not granted any interim relief but has suspended the fundamental rights. Let us first understand the grounds on which interim relief is granted. Now there are 3 grounds for granting interim relief. First, that there must be a prima facie case. It means that the petitioners have to prove only that there is a valid argument and for which they have quoted various cases in which the court has agreed that wearing hijab is a part of their religious identity. The second ground is the balance of convenience, in which the court has to find a balance where the both respondent and the petitioners do not face grave injury. And the third ground is irreparable injury. It means that the interim relief must not cause irreparable injury. But here, the order has essentially suspended 3 fundamental rights. Article 25, Article 21, where wearing hijab becomes a part of one's identity, means one's right to privacy, the right to choice, right to wear clothing of their own choice. And third article, Article 19, Clause 1, A, which is right to freedom of speech and expression. Although the court has taken stand that since it is a matter of few days, students can give up wearing hijabs for attending classes, but then it comes a matter of this or that in which a student has to forego their religious faith for accessing state provided education. What are your views on this decision by the High Court, and what do you think about the Karnataka government's circular regarding hijab ban in educational institutions? Post your views in the comment section and let us have a constructive debate on the topic of right to freedom of religion. Give a thumbs up if you like this video and subscribe if you are new to this channel. Thanks for watching. Have a nice day.